On behalf of Gora Chand Pattanaik Memorial Trust, welcome you all to the 9th Gora Chand Pattanaik Law Lecture in this historic venue of Bhanjagala Manda. After the COVID pandemic, this is the second successive Memorial Law Lecture. As we delve into the intricacies of our legal landscape, we must first understand the symbiotic dance between the bar, representing advocacy, and the bench, embodying adjudication. Gathered here today, we embark on a journey to dissect the dichotomy between the bar, the stage where legal narratives unfold, and the bench, the seat of judicial authority. To start with, may I now welcome our most revered guest and the chief speaker of the law lecture of today's evening, Honorable Dr. Justice Vidyut Ranjan Sarangi, Senior Most Judge, Orissa High Court, on the dais. I would also welcome Shri Sitanshu Mohan Dwivedi, Chairman, Orissa State Bar Council, up on the dais. I would like to welcome the Chairman of the Trust, Shri Jagannath Das, on the dais. Lastly, I would also welcome the Managing Trustee, Shri Subhashish Pattanaik, on the dais. We are also privileged to have amongst us off the dais Honorable Justice V. Narsingh, Honorable Justice Aditya Mohapatra, and Honorable Justice Shiv Shankar Mishra. Sir, we are privileged to have you amongst us. It is with great pleasure and gratitude I request Varshani Dash, Anandita Bisoi, Rushani Mohapatra, and Gunjan Mohanty to present flower bouquets to the guests on the dais. Moving on, with reverence and respect, I invite each and every one of you to please rise from your seats for the state anthem.
Bonde utkara janani, 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 bonde utkara janani. Charu bhasamai, janani, janani, janani. Bonde utkara janani, bonde utkara janani. Payodhi vidhauta sarira, taratmana sushobhita tira, subhatini kura sikara samira, janani, janani, janani. Bonde utkara janani, bonde utkara janani. Ghana ghana vana bhumi rajita pange, neela kudhara mala sajita range, kala kala mukharita charu bihange, janani, janani, janani. Bonde utkara janani, bonde utkara janani. Vande utkara janani, janani.
Now, I would invite our dignitaries to please step forward and proceed with the lighting of the lamp.
तो समय नहीं ना 5:30 तो फोन करते ही पहुंच
दीपं ज्योति परं ब्रह्मा दीपं ज्योति जनार्दना दीपं ज्योति हरतु मे पापम् संध्यादीपो नमोस्तुते ॐ शान्ति शान्ति शान्तिः
से करना तो पड़ा करना तो
Thank you, dignitaries. May the light of knowledge continue to shine brightly within us. The bar crafts the arguments, but it's the bench that weighs them with the scales of justice. Without further ado, I would like to request Shri Chittaranjan Redressal, Trustee, to deliver the welcome address for today's evening.
Namaskar, very good evening all of you. I, Sri Chittaranjan Redressal, Trustee Gora Chand Pattanaik Memorial Trust, welcome you all to this 9th Gora Chand Pattanaik Memorial Law Lecture. Ladies and gentlemen, before commencing my opening address, with permission of the Chair, I want to mention, as we all gather today for this Memorial Law Lecture, let us take a moment to honor and remember the departed souls who have contributed immensely to the legal fraternity and founded the trust. Yes, I am talking about late Arijit Kumar Das, who was the founding chairman of this trust, and also late Pratap Kumar Das, who was also the founding managing trustee of the trust, who along with us founded this trust some 2004. Unfortunately, during the COVID pandemic, Sri Pratap Kumar Das left for Heaven Day Board. Then last year, we lost Ajit Kumar Das to prolonged illness. Their legacy lives on in the principle and the values they upheld. With the permission of the Chair, now I request observing 1 minute silence for the departed souls. Thank you. Ladies and gentlemen, we are deeply elated to welcome Honorable Dr. Justice Bidut Ranjan Sarangi, the senior most judge of Orissa High Court, who has given his kind consent to be the speaker on the topic today, the bar and bench, two facets of the judiciary. Honorable Dr. Justice holds a distinguished position as a judge where his judicious wisdom and commitment to justice have left an indelible mark on the legal landscape. Hailing from a village in the district of Nayagar, Dr. Justice Sarangi passed his graduation in Commerce with honors from BJP College and acquired LLB and LLM degrees from MS Law College, Cuttack. He was awarded PhD in Law from Sambalpur University and also received many awards for his academic excellence. Dr. Justice Sarangi joined the bar in the year 1985 under the tutelage of the great doyen of the bar, late Gangadhar, the former Advocate General, senior advocate, who was also legal luminary and also a jurist. Dr. Justice Sarangi practiced in the High Court of Orissa as well as the Supreme Court of India. He practiced in all branches of law, appeared for the private parties, corporations, government undertakings, banks, insurance companies, schools, colleges, Lokpal of Orissa, human rights. If I name them, it will be a book. For his outstanding performance and his standard of professional ethics as a lawyer, he was conferred with the Haricharan Mukherjee Memorial Award with a gold medal for the year 2002 from the then Chief Justice of Orissa High Court, Justice P.K. Balasubramanian. After 27 years of practice at the bar, he was elevated as the permanent judge of the Orissa High Court on 20th June 2015. Throughout his illustrious career as a judge, Dr. Justice Sarangi has exemplified the highest standard of integrity, impartiality and legal acumen. His dedication in upholding the principle of justice and fairness has earned him widespread admiration and respect within the legal fraternity and beyond. Today, we are privileged to have Dr. Justice Sarangi grace us with his presence and share his invaluable insights on the topic, the bar and the bench, two facets of judiciary. Ladies and gentlemen, please join me extending a warm welcome to Honorable Dr. Justice Ladies and gentlemen, it is with great pleasure and reverence that we extend a warm welcome to Mr. Sitanshu Kumar Dwivedi, the distinguished chairman of Orissa State Bar Council, as our esteemed guest today to inaugurate the Memorial Law Lecture and give the keynote address on the topic. Mr. Sitanshu Mohan Dwivedi epitomizes the lawyer's leadership within the state of Orissa. As the head of the Bar Council, he holds a pivotal role in shaping the course of legal practice and upholding the principle of justice in our society. Mr. Sitanshu Mohan Dwivedi, after completing his Masters in Law, joined practice in the year 1990 in the chamber of Mr. Nirmal Kishore Pattanaik, a senior-most member of the Bhubaneswar Bar Association. Mr. Dwivedi practiced in almost all branches of law. His exceptional leadership quality made him one of the youngest advocates to be elected as the member of Orissa State Bar Council in the year 2002. Since then, continuously he got elected to the Orissa State Bar Council as the most popular and most experienced leader. Sri Dwivedi was elected as the chairman of the Orissa State Bar Council in the recently concluded election. During his career as a successful lawyer, Sri Dwivedi represented many corporate houses, individuals and bagged many awards like Ekamlasri Award by the Honorable Governor of Orissa, Rajdhani Gaurav Samman 2015, Achievement Award by the Bar Council of India in 2004 and many more. Under his stewardship, the Orissa State Bar Council is continuing to thrive as a beacon of legal advocacy, ensuring access to justice for all, and he is also responsible in fostering a culture of integrity and excellence within the legal community. Today, we are honored to have Sri Dwivedi grace with his presence and share his valuable insights on the topic bar and bench, two facets of judiciary. Thank you. Now let's come to the topic. The topic, many of my friends said that it's an old topic. This topic does have a very little relevance today. But I tell you, the relationship between the bar and the bench is a cornerstone of the justice delivery mechanism. These dynamic interactions shapes the administration of justice, influences legal precedents, and ultimately impacts the society as a whole. Collaboration between the bar and the bench is essential for the effective functioning of the justice delivery system. Lawyers rely on judges to provide fair, timely adjudication, while judges depend on the bar to present well-reasoned arguments and uphold ethical standards and legal practice. However, tension can arise between the bar and the bench at times. It does, even today. particularly when there are disagreements over legal interpretations, procedural matters, or the conduct of legal professionals. Maintaining a harmonious relationship requires two open communication, professionalism, and a shared commitment in upholding the principle of law, rule of law, and justice. I do accept that this particular fact, given rise to the importance of this particular subject, it will be important, it remains as important, because if either of the domain they overreach the other domain, definitely confrontation creates problems. And the challenges are there. I think we have to discuss on that particular topic today. Thank you. Thank you.
I request Mr. Jagannath Das to give his chairman's address about the trust.
नमस्कार, शुभ संध्या, गुड इवनिंग. I am Mr. Jagannath Das, Chairman of Gora Chand Pattanaik Memorial Trust. Respected Honorable Justice B.R. Sarangi, Judge Orissa High Court. Respected Chairman Orissa State Bar Council, Sri Sitanshu Mohan Dwivedi. Respected Member of the Judiciary, Constitutional and Statutory Authorities. Respected members of the Bar, Praise, my esteemed members of the bar, ladies and gentlemen. I take privilege of saying few words about the trust, why we formed the trust in a memory of our late seniors, and so far as Late Gora Chand Pattanaik, an eminent advocate of Bhubaneswar bar. I pause a moment here because I have to say something I shared in my life, because since 87 till his demise, I am with him. I am experienced each and every moment, not only in the professional matters, but also some of the personal matters. So thing is that I appraise you, जे एभली एक महान व्यक्तित्व आजिका दुनिया रे विरल कहले अत्युक्ति हेब ना. एइति पई मु जेतेबेले एमएस लॉ कॉलेज रे पढु थाए सेतेबेले माय लॉर्ड मो सीनियर बैच आ मोर जने बड़ भाई थिले बलराम खरा जे कि सार के अति क्लोज फ्रेंड. सेतेबेले मु इंस्पायर हेतिली आ जेतेबेले देखि जे एना से रेगुलर क्लास करथले मु मध्य क्लास करथली हाथे रे निश्चित बही थिबो नोटबुक थिबो जोटा कि आजिका दुनिया रे विरल. अवश्य आजिकल तो मोबाइल हेलान सेटार कि आवश्यकता नाही कहले चले. परवर्ती समय रे जेतेबेले प्रोफेशन को आसिले माय लॉर्ड मु 4-6 थर देखिछि जेते सीनियर को एते निकटतर काहे किभली भाव हेई पारंदी सेटा मो मन रे टिके गभीर रेखापात करथिला. सेटा मु केमति मो जीवन रे लगेई पारिबी सेटा मु शिक्षा करथिली फ्रॉम माय लॉर्ड जस्टिस बी आर सारंगी. दैट इज अ ग्रेट इंस्पिरेशन टू मी इन माय प्रोफेशन. सेतबेले मु जॉइन कला बेलको रुद्र प्रसाद नंद जी की वर्तमान जीपी से मो ऊपर रे थांती. गोटे जिस देखिली से एते मात्रा रे सार ता भल पाउतले मु ता कारण मते बुझिबा पे के मिनिमम 6 मास लागिला. आ से 6 मास भीतर मु देखिली तार कारण होउची एक रे सिंसियरिटी एमती को दिन नाही जे के चैम्बर मिस करत. द्वितीय ताकर डिवोशन टू द प्रोफेशन सार जहा कहंती ताको अक्षर अक्षर पालन करन. आ से तो उथिल अबनी पटनायक, प्रमोद महांती, प्रदीप्त नंद जी के ना वर्तमान प्रोफेशन ना से समय तापर कालक्रम से जीपी हेला पर चैम्बर छाड़ले एवं मु आसिली केते गुडे जिनिस संगे एभली भल पाइबा जूनियर मान को निजर पो भलिया एभली व्यक्ति आजिका दुनिया रे विरल. सेति पे गुटे जिनिस त्याग रहिले साधारण आउ स्नेह श्रद्धा रहिले जूनियर मान कि शिक्षा करिवे सीनियर. आजिका दिन रे टिके सेटा विलुप्त प्राय हेलानी कहले चले. आ से अनुसार भाइस वर्षा जूनियर मान मध्य सीनियर मान प्रति सेही भली भाव रे ताकर आचरण मध्य परिलक्षित है। गोटे कथा मु कहबी मो जीवन रे मोर मन रे दुख आसला सार प्रति आउ सेटा परवर्ती समय मु कहली गोटे केस रे महापात्र ट्रैक 1 कोर्ट रे गोटे अपील हियरिंग बेले से तो मु केस करिवार क्षमता आसी जाइतला मोर सेटा सार निजे फाइल पत्र धरि के गले सर मन दुख होला मुझे एटा कोन करि पा नथि सार काहे कि मते अवॉइड कर कहना से तो से प्राय रुद्र हैना थिला बेले से काम छाड़ी देथिले सब निजे किछि करनथले आम ऊपर छाड़ी देथिले निजे बसथुले हाथ धरि के चलौथले सिखौथले से केस सरिगिरी आसिला परे चांबर तांको पाखरे मु बसे मु पचारली सर ए केसटा कोन मु करि पान थांते मते अनेले तापर कहिले से केस विषय तुम जानिछ मेरिट अछि नहीं सर मेरिट ना से लोको जेते बेले तमे करि थांत केस हम विरुद्ध रे जाई थांता से कोन कहि थांता एक तो पेमेंट नहीं तुम जानिछ सेकेंडली तुम ऊपर कहि से गोटे लोक भाबिबो जदि गोराचंद गोराबू करथांते मु केसटा जीति पारथान से जूनियर को दे देले तुम मुंडरे कहि कि मु ब्लेमटा छाड़ीबे मु कहि से ब्लेमटा न नेबी तमर वर्तमान ग्रोइंग पीरियड तुम ऊपर मु कहि से ब्लेमटा छाड़ीबी मु सेटु कान मोड़ेली मु सेटु मन मन भाबिली जे मोर बोकामी केते एई भली अनेक क्षेत्र रे से कथा तो कहिले सरीब नै वर्तमान भी समय नै मु करिबा कोसे समय खाली केते ओडी उदाहरण देली आउ गोटे दिन ताकर व्यक्तिगत कथा मु कहबी आउ सेतिके रे मो अन्य ट्रस्ट रो ऑब्जेक्ट विषय रे 5 मिनिट कहि कि मो वक्तव्य रखिबी काना समस्त कर आकर्षण सा तेणु से विषय रे मु कहबी माय लॉर्ड कहबे सब कथा गोटे कथा दिनकर कथा चांबर को मु आसिला को वर्षा हला एंटायर मु पूरा भिजी जायते शरीर रो पोशाक सब भिजी जायते मते देखि देले पूरा भिजी जाय सारा वर्षा हला गले घर गले दुईटा टर्किस लेकिन आसिले ताकर मते देले कहले जाओ बदल के पुछे के बस लुगापटा पक्का सुखिले बस बस जाब एभली बात जो आत्मीयता भेरी भेरी रेयर आजिका दुनिया रे सेति पाई मु कहिबी हम समस्त जे काम करिछथि तांको पाखरे एभली भाबे अनुप्राणित होते भल पाई छथि तांकर मेमोरी के मेंटेन करबा पाई ए ट्रस्ट आमे गठन करिछु आउ ए ट्रस्ट रो जो ऑब्जेक्ट हमर किछिटा मु आपन मन पाखे परिप्रकाश करूची The trust was formed to encourage young lawyers and students pursuing law to grow themselves as better professionals by developing their personality and understanding the various aspects of law. Amongst other purposes of the trust, it is the duty of the trust to maintain up-to-date library and to organize the law lecturers, workshops, seminars and legal discussions. In the memory of departed soul, the trust organized law lecturers in Bhubaneswar. In fact, it is the only trust which organizes law lectures at Bhubaneswar. The law lectures organized by the trust are attended mostly by legal luminaries of the state, advocates, judicial officers, bureaucrats, journalists, and persons from all walks of the life. So far as trust has conducted 8 law lectures, including this. On 27/3/2005, the first law lecture was on judicial activism in dispensing social justice, delivered by Justice L.K. Mohapatra and Justice B.P. Das, then judges of the Orissa High Court. On 24/3/2006, the second law lecture was on alternative dispute redressal mechanism in dispensing justice, delivered by Justice Arijit Pasayat, then Judge of Supreme Court of India. Third law lecture was organized on child-friendly justice, delivered by the Honorable Chief Justice Orissa High Court, Sri Justice A.K. Ganguly. Then fourth law lecture was a reasonableness of restriction on reporting the matters of judice, delivered by Justice G.N. Rai, the then Chairman Press Council of India. Then fifth law lecture was on advocacy, delivered by Justice Indrajit Mohanty, the then Judge Orissa High Court. The sixth law lecture was on Can India become a social state contemplated in preamble of our constitution? Delivered by Justice A.K. Pattanaik, the Supreme Court of India. Then seventh law lecture was on separation of powers under Indian constitution, delivered by Justice A.K. Pattanaik, the then Judge Supreme Court of India.
Chairman, Orissa State Bar Council, to share his wealth of knowledge and experience with this august gathering. Sir, please.
Good evening to everybody. Jai Jagannath. Honorable Chairman, Honorable Managing Trustee of the Trust, Honorable Dr. Justice Sarangi, Senior Judge, Orissa High Court, Honorable Justice B. Nursing, Honorable Judge, Orissa High Court, Honorable Justice Sri Aditya Kumar Mohapatra, Honorable Judge, Orissa High Court, Honorable Justice Shiva Shankar Misra, Honorable Judge, Orissa High Court, most respected Senior Advocate, Honorable District Judge, Special Judge, Vigilance Judge, other judges, friends, most affectionate brothers and sisters. We are privileged and enlightened to hear the deliberation on the topic. I will confine to my limitation. Judiciary is a combination of bench and bar, including litigants and applicants. Laws are to be used than to be misused. Laws are to be understood than to be misunderstood. Laws are to be interpreted than to be misinterpreted. Implementation of law is required for the best interest of society at large. Legal awareness is precautionary measure to solve the legal dispute in time in rightful manner. People are unclear, needs clarity of law. Legal awareness are required to educate each citizen for their survival. When people lost confidence upon any authority, either on an individual or by any institution or even by government, when somebody is being harassed and deprived to get his legitimate right, then he preferred to knock the door of justice, and judiciary is the pillar of justice to safeguard and protect the interest by means of distributive justice. The legal profession is not only a noble profession but also considered as one of the best professions having multiple opportunities. Good professionals are like shining sun and star in the sky. The professionals who render their valuable service in guiding and shaping for a better future will never be forgotten by the people of our country. The legal practitioners are indispensable and inseparable from democracy and the functioning of judiciary. I would like to quote the quotation of Justice Krishna Iyer. We are the priests in the court of law and not traders bargaining with the customer. It is a profession and not a business. We are placed on the highest pedestal in the system. A lawyer should be dynamic, vigorous and technically strong. He should not mislead his client in a false belief that he will win the case even if it appears prima facie that there is no merit in his case and a loss is certain. In his relations with his client, the lawyer should be frank and do only as much as he deems the best he could do in that matter. Legal awareness for each lawyer is a precautionary measure to solve legal dispute in time in rightful manner. People are unclear, needs clarity of law, for which legal awareness are required to educate each citizen not only to save their property and life but also for their survival in the society. Judiciary is combination of both bench, bar, including litigants and applicants. Laws are to be used than to be misused. Implementation of laws are required to be implemented in time, in rightful manner for the best interest of the society at large. Bench and bar are two arms of the same machinery, and unless and until they will work harmoniously, justice cannot properly administered through the court of law. Bar is the link to obtain justice from the bench on behalf of aggrieved persons. Advocates used to address the legitimate grievance of litigant, whether it may be a civil matter, it may be a criminal jurisdiction or constitutional jurisdiction or any other law, but the lawyer is required to be educated both factually and legally before ventilating the grievances of the party for which lawyer must be educated. A lawyer should be polite, should be humble, submissive and academically sound, as well as having minimum required knowledge in both facts and laws. The conduct of the lawyer should be submissive. The lawyer must have patience to hear the grievance of litigants. Before parting, I would like to quote quotation of Abraham Lincoln: "Discourage litigation, persuade your neighbors, if you can point out to them that the nominal winner is often a real loser in fees, expenses and waste of time. As a peacemaker, a lawyer has a superior opportunity of being good person." We used to speak, our profession is a noble profession and we are member of the noble profession. Noble personalities like Utkal Gaurav Madhusudan Das, Utkal Mani Gopabandhu Das, father of our nation, Mahatma Gandhiji, Iron Man, Sardar Vallabhbhai Patel, Constitution maker, Dr. B.R. Ambedkar, first Prime Minister of independent India, Pandit Jawaharlal Nehru, have remarkable and tremendous contribution, not only limited in the legal field, but also extended to promote social, economical, political, and for the progress and welfare of our nation at large. We are in noble profession. Bench and bar are two sides of the same coin. Unless until both will work harmoniously, justice cannot properly administer through court of law. Long live legal profession for achievement of constitutional goal and to make a strong and independent judiciary to bring a better future. Now we are privileged to hear the valuable suggestion or the discussion from our Honorable Chief Guest, Chief Speaker, Honorable Senior Judge, Dr. Vidut Pradhan Sarangi. So now I complete my speech. Jai Jagannath.
Thank you, sir, for inspiring us to new heights of understanding. Within the hallowed halls of justice, the bar and the bench stands as sentinels guarding the gates of fairness and equity with unwavering resolve. It is with great anticipation and excitement I kindly request our revered guest for the evening, Honorable Dr. Justice Vidyut Ranjan Sarangi, to share his invaluable knowledge and perspective with our attentive audience.
Jai Jagannath. My esteemed Professor Jayadep Pati, who was my teacher, philosopher, guide. I have worked under him. If I am today here, it is his contribution. I am here, so I give my gratitude to you. I am visiting off the dais. Sir, anything wrong goes. Now I want to rectify myself, and please guide me as my teacher, as was doing earlier. Today also do it. I cordially invite my wrongs to rectify by my teacher who is present here. My esteemed brother judges, Honorable Justice Nursing, Honorable Justice Arijit Mohapatra, Honorable Justice Dispensing, and of the dais, the Chairman of the Bar Council, Shri Mohan Dwivedi, the President and the Chairman of this Gora Chand Oral Committee, Mr. Jagannath Das, who is present here. He was just junior to me. I was very happy that at least he is inspired by me and good lawyer of Bhubaneswar bar. I expect he must rise to the occasion and he must grow in his life. My dear Judicial Officers and also the entire team of Judicial Officers present here. This is the occasion where we have to share our knowledge and we must understand each other and how to perform our duty and responsibility assigned to us. As a judge, what we have to do and what not we have to do, that we have to consider. And above all, my esteemed seniors, Mr. Jair Bhai, Mr. Jena, Mr. Sarangi, Mr. Mohapatra, Mr. Pattanaik, all the known faces are sitting here. I am very happy that you all are here to hear me. I am really grateful to you. And this is a place where we have to learn each other. It is not that I know everything or you know everything. It is sharing of knowledge. And today also I am continuing as a skilled student of law. And I am not interested to learn. Even yesterday's students were joined the profession and from any other person who has assisted me in any work. Therefore, the learning process continues till I die. And any good suggestions, any good inspirations come from any side, it is welcome. I really appreciate your presence here and I really appreciate that you all are here to encourage me to learn something and share with me that whether I am saying the correct thing or wrong thing. If I am wrong, you are free to make any suggestions from your side. I fully accept it so that I can rectify myself. If I am right, no requirement any compliment to me. But before I start, I just pointed out that how I know the Gora Chand Pattanaik, who is no more with us, the great soul. When in initial days of my practice I was coming to the Bhubaneswar to do cases, I saw, watching in the courtroom also, a great learning. You know the different types of lawyers have different types of way of submissions, way of carrying the court with them, and way of understanding, and way of presentation, way of preparation, way of knowledge to share. So when I see that, when I saw him, he was doing a civil matter and moving an injunction application before the Civil Justice Senior Division at Bhubaneswar. I was so impressed. Then I sought about his identity. Then some of my close friends told me that he is Mr. Gora Chand Pattanaik. Then the search was going on. Then I find he is very close to us and close to us in the sense from Noida connection. And I find that he was born in Dadivasagari at Khordha in 1929. Then had this practice initially at Puri. Thereafter, when 1959 the Bhubaneswar court was established, he shifted his practice to Bhubaneswar and become a established lawyer here. I am happy that most of the juniors are doing very well and most of these juniors have established themselves. It is only guidance of the great soul, Late Gora Chand Pattanaik. I offer my full tribute to him on this occasion, and I believe that the education, the learning, the transformation of the law which has been taught by him and duly propelled by his able juniors. I congratulate them that they have formulated a trust and have this lecture series, and today is the 9th lecture series where we have to discuss about the subject, the bar and bench, the two facets of judiciary. So, though the things looks very easy, then one may say, what is this bar and bench relationship? And two facets of the judiciary. These are very well-known things, nothing is there, but I feel it is a very sensitive, complicated and very, very difficult thing to present before you, though it seems to be very, very simple. But it is not that simple which we understand, and it is my understanding that the things which we think that is very, very easy, it is very, very difficult to present. Therefore, I can say that let us understand what do we mean by bar. If I go to section 2011 of the Licensing Act 1964, it defines, it includes a place which is exclusively or mainly used for the sale of consumption of intoxicating liquor. You will be excited to know that. That bar is where the liquor is sold or used, that can be called as bar. In other provisions of the statute also, in section entry 26 capital A1 of the Central Excise and Salt Act, it has been held that the term bar occurring in the entry 26 A1 of the Act would be include the rod, that is iron rod. So, are you discussing matter about that bar? Is it that liquor bar or is that iron bar? Answer is obviously no. Then where do we stand? The question is that let us know the meaning of the bar for which we are now dedicating ourselves to have a discussion. The question is that the essential consideration is the practicing member of a legal profession in a given community. All those who have right to plead in a court are called the bar. So we have this category, now we have to discuss. Forget that bar of the liquor bar, forget that iron bar. Now we have to be class of a bar which comes under this category, and the whole body of the attorney and counsellors or the members of the legal profession collectively or figuratively call the bar from the place which they usually occupy in the court. They are thus distinguished from the bench, which term denotes the whole of the body of the judges. The Encyclopedia Britannica Volume 3, page 92, the term bar is legal parlance originated in England with partition of bar fixed or dividing the court hall into two segments for the purpose of separating lawyers and officers of the court from suitors and on the general public. That means must be seen that in a courtroom there is a barrier between the court and the lawyers and the clients. Does it mean that yes, that bar itself create a distinction between the members of the bar and distinction between the bench, the judges? Answer is yes. Because this is the dividing line between two class of people, namely one is bar, that is the legal luminaries, the lawyers, those are practicing, and other side the bench, the honorable judges, those are the the court, and they have to discharge their responsibility assigned to them. Now the Encyclopedia Britannica, volume 3 and page 214, it has been indicated that over the years, the bar as connected with the law denoted a dividing line, though not made any material, but yet identification which separated the public from the principles of court, and the term bar in a courtroom applied to an area implied reserved for the principals of the court and the judges, the attorneys, the court officers and members of the jury. The corpus juris of secondum volume 9, page 1537, bar is defined as place which counsellors and advocates occupy in the courtroom. The Bauer Law Dictionary, the term bar is defined as a particular part of courtroom where lawyers sit. Similarly, the bench is the seat where judges sit in court. The seat of justice, a court is to decide particular matter or matters. The Rajendra Pasayat versus Shivbhadra, AI 1967 Supreme Court, page 1445, it has been held that the word bench includes a single judge or it does not necessarily mean two or more judges. In Kalipada Das versus Kiran Dashi, 1958 Criminal Law Journal, page 572, Calcutta, while dealing with the Bengal Village Self-Government Act, the court held that the word bench has not been defined in Act, but it is clear from section 65 of the bench, 65 that the bench would mean two or more members constituting the bench. Therefore, this being the meaning of the bench and bar, one cannot survive leaving each other. That is why it is said that the bench and bar are the both wheels of the justice. If one wheel is left unrepaired, the machinery of the administration of justice is bound to crack dangerously, if not stop altogether. It is very often said that bar and bench is the two sides of the same coin, what the Bar Council Chairman already said. This speaks a volume of the things. It is very easy to say that bar and bench is the two sides of the same coin, but it speaks volume of the things. Why I am saying so? Bar and bench is inseparable. They have to work together for the dispensation justice delivery system. Without one, it is not possible to discharge the obligation under the Constitution for the citizen of country. The bench and the bar both are instruments of justice, and justice cannot be effectively administered if the relationship between the two is grossly imbalanced or one is favored at the expense of others. It is very, very easy to say that is both sides one kind, but while acting, you have to judge yourself how to function as a bar member and how a judge has to function as a bench. Therefore, these are the things which I want to point out, make a distinction and also indicate what one has to do. If I pose a question to myself, what is the source of this members of the bar? Then answer will obviously that a person having law degree can be joined the profession as a lawyer and he can be a member of the bar. So also the requirement of the bench member is the same. Therefore, source of bar and bench is the same because one has to have the qualification of law degree with him so that they both can be eligible to become a lawyer or to become a member of the bench. Therefore, the source being one, then when one can be called as bar member and one can be called as bench member, that is to be said that whether a person is a member of the bench or is a member of the bar, it comes from the same category of persons, namely the law graduates who opt to work for the legal side. In many cases, judges are taken from the lawyers. Thus, wherever you may go, whichever state you may travel, you will come across persons who are sometime members of the bar are now the members of the bench, or who sometimes were the members of the bench are now the members of the bar. And besides this, you will come across persons who are not satisfied as members of the bar and want to join service, and persons who are not satisfied as a judge and want to join practice. This being the state of affairs, one can simply say that they are two sides of the same coin and they belong to the same noble profession. It is all a difference, a degree, not a kind, and in fact, there is no difference at all as lawyers are also equally the judicial officer of the court. Therefore, bar and bench called the mother. Bar is called the mother of the bench. Therefore, you cannot say that because we are judges, we have been come from heaven. Answer is great no, absolutely not. Even if I am a judge, my mother is my bar. I was in the bar. The bar has ravished me. Bar has allowed me to grow, bar has allowed me to see the bad and good of these things. Then when I elevated to a judge, I become once a member of this bench, but that does mean that I have born and come from heaven. Rather, I would say all emphasis that the bar is the mother of the bench. Today, if somebody is the bench, tomorrow he may go and join the bar also. And many of the practitioners will decide that yesterday those are in the bar. I am talking about myself and my three of the other judges who are sitting here. They are all from the bar. I am very lucky that these people are from the bar. They have seen the good and bad of the bar itself, and today they have occupied this chair and discharging their responsibility as a bench member. Tomorrow they will complete their work. If they want to have to go to the bar, then this bar welcome them and they will come to the lab. Therefore, the understanding is very clear. There is no ambiguity about understanding itself. Likewise, if somebody is not satisfied with the bar itself, then he may also say, oh no, it is not possible that bar to survive here. I have to go. Then he may opt for this bench. They may come to judicial service method. The process have to follow, selection process. By following process, all the judicial officers of mine are sitting here. They have come to the process of selection. They have now occupied the bench. Tomorrow, after completion of their services, they want to join the bar also. They will go and join the bar, and bar never say, no, don't come here. You are not touching me. No, that's not. Bar always welcome them. All like yesterday you are there, today you come to us. You will gladly accept you. Yesterday you are not accepting us, today we are accepting you. Please come. So these are the things which is very sensitive issue, but very practical issue that we have to accept with gladness and with all reverence, so that at least one cannot forget his past. Therefore, I always say, my brother judges, that don't forget your past. Suppose a lawyer is facing some difficulties. You have been elevated, it's all right, no problem for that. But question is, that if lawyer faces some difficulties, let us assist him to say something good. If not today, tomorrow, allow him to come prepared, so that at least he will be educated himself and simultaneously pass on his education to us, and we will be enriched with our knowledge. This sharing of knowledge between the bar and bench will continue. Therefore, I understand that this understanding of relations with the bar and bench is very strong, not severable, and that too, we may not, some professional ethics view, you are away from us with a bar which has been kept in the court. You are standing in different place, we are sitting in different place. But still then, for the growth of the judiciary, the understanding of law between the bar and bench has to be taken into consideration, and understanding should be in a manner which is required to be done under the law. And you are the person who are to supplement your knowledge with the court, so that the court can enrich his knowledge and deliver justice to the public. Now, coming to the question I am posing to myself, that what an advocate can possess. This is a very difficult and sensitive question, but still then I have to answer it, because these questions I have formulated myself, and I wanted to deliver this set and place for you for kind consideration, so that tomorrow you will not face any difficulties when you analyze yourself standing in my place or your place, so that the justice delivery system continue smoothly. So, about Pari, the advocated 7 lamps of advocacy such as honesty, courage, industry, wit, eloquence, judgment, and fellowship, along with worthy character exhorted to practice then in their professional life. The profession is not without its dilemmas sometimes. A situation may arise when a lawyer has to submit to the court that he has no case, but he shall not do so when a new legal principle he wants to lay before the court, even while citing an overruled decision contrary to his own contention. I think we must be understanding what the above parish says. again I am pressing for consideration. Honesty, courage, industry, wit, eloquence, judgment, and fellowship, along with worthy character, and exhorted to practice them in their professional life. The profession is not without its dilemmas sometimes. A situation may arise when a lawyer has to submit to the court that he has no case, but he shall not do so when a new legal principle is wants to lay before the court, even while citing a overruled decision contrary to his own contention. Therefore, if a lawyer thinks himself that he has no case and plays before the court, I have no case, but even if he says so also, if some new point strikes his mind, he is not reputed to place that point before you. If the new point can be placed before the court, then the court cannot say that I am not taking into consideration that. Even if the lawyer has already expressed that he has no case, but he is trying to develop a new point. That new point has to be taken into consideration even if he has no case. So don't close your eyes, don't close your heart, don't close your mind. Rather, the new point which has been advanced by the lawyer himself has to be taken into consideration by the bench when they are adjudicating the matter. Let us say that for some reason or other, he is showing some overall judgments, but if the point is appealing to the court itself, then certainly the court can enter the case and also pass on his views may be against him, but he cannot preclude the lawyer not to hear him. He has to give sufficient opportunity to the lawyer to say whatever point he wants to argue the matter, let him argue, let him press his point, at least we will decide the matter what point is pressing for the court, even though he has no case at all. And even if he says orally that I have no case, but still then I am trying to place some points you also can consider it. This is the situation which you have to come through. Now coming to the great judge of India, the former Chief Justice of India, Justice Venkatacharya, while reminding his father, who was his senior, advised the members, I quote, to keep this silver lamp of learning bright, not remain a mere professional robot, and therefore read everything, at least 10 pages of reading a general classic and 10 pages of legal classic a day, which would keep devil of ignorance away. He pointed out with emphasis that law is not to only say, a lawyer is to get himself ready by enriched knowledge. How will enrich knowledge? Only by reading. Maybe he may not like to read some case laws, he may read some other books which enrich knowledge, and that will one day will help him to argue some matters. Therefore, lawyers' knowledge is very, very important for us to enrich our knowledge also. Thereby he says that read every day at least 10 pages of reading of general classic and 10 pages of legal classic a day, which will keep the devil ignorance away. So you say, I don't know, that I don't know to go from your mind. If you keep on habiting reading the things, either the legal classic or general classic as you like. It is true that life of an advocate can be divided into 3 places. Life of an advocate can be divided into 3 places. 1, his home. 2, the chambers. And 3, the open courts. But if his home makes him a man, if he is at home, makes him a man. If he is in chamber, a professional. And if it is court, which makes him a true, dignified and committed lawyer, reminding him the rights and duties cast on him by his noble profession. So these are the 3 stages you have to come through. And that too, the 3 pages is very important for you. So long you are in home, it's not some normal man, they don't feel for that. If you are in chamber, you are professional. But when you are discharged your responsibility to the court itself, the other things are, that is, he is a committed, dignified and committed lawyer, reminding him of the rights and duties cast on him by his noble profession and professional competence. by hard work. It is not possible to become a good lawyer. It is not possible to deliver the goods unless you have the hard work. So these are the things you have to take note of. Now, I just take note of Edmund Burke said that the law sharpens the minds by narrowing it, but in a few of our great judges, law has lifted the mind to a level of comprehension and has kindled a degree of human ardor unsurpassed in any other profession, and the profession of lawyer is undoubtedly great. Gerald S. Urbas writes in his book of Unequal Justice, law is a mirror of social forces. It reflects what is in society, but if it exerts the autonomous power to channel special problems and public issues into its own constricted framework and legitimacy and procedure, then it may become detached from its social mooring, and consequently bar must be judged by true standards but not by double standards. By true standards, not by double standards. What is that true standards? One, its sensitivity to the values and mores of the society. Then two, its implementation of obligation to provide equal justice under law. In theory, the bar assumes both transient and transcendental the responsibility to serve clients and to serve justice. Although the lawyers equate these and assess that they do one when they do the other, it is not so. A total commitment to the former may preclude any commitment to the latter. Now, B.R. Ambedkar, the founding father of the Constitution, and described the Indian judicial system as, I quote, one single integrated judiciary having jurisdiction and providing remedies in all cases arising under the constitutional law, civil law, or the criminal law. I quote. Now coming to Folius Nariman, an eminent jurist, senior advocate, former Attorney General of Supreme Court of India, in his book Before Memory Fades, he said, I quote, after choosing law as a career, he had undergone meticulous training under the eminent lawyer by joining his office of Jamsetji Kaga, who used to say, I quote, lawyer never stops learning the law. Lawyer never stops learning the law. When you mention a famous race horse, they always ask you from which stable. The stable is important. It establishes ancestry, pedigree, and the breed. Likewise, when you name a lawyer who was done well, the people ask you from which chamber. I am just pointing out, when Jagannath Das was staying before you, if you argue well, then definitely from which chamber he has come. Definitely I am saying he is from Gora Chand Pattanaik chamber. So this identification which he has got today, and for whom he is boasting, I am saying that my senior is an extremely good one, and I have found none other than my senior to be good because of this fact, because he has taught and allowed to work and place something before the court which has been appreciated by others, and everybody asks from which stable, means he belongs to Gora Chand Pattanaik's office. That is the identification thing. He had no identification when he joined the bar. He had come alone. And he was just searching for a place where to fit in. And once he joined the office of Gora Chand Pattanaik, he was fit into that office and tried to deliver the goods. And I always feel proud of my senior. Today I am here, it is because of late Gangadhar, the former Attorney General of the state and senior, who was not my senior alone. He was my guide, philosopher, what not. He has guided me in any respect, maybe in personal level also, but he is a hard tax master. if he is a hard taskmaster, then you may feel something bad during his continuance, but ultimately it will give proof to you. And today, if I am here to say something, it is because of his guidance, his education, his training, and his blessings. I am here. I am deeply obliged to him for his contribution to me, and simultaneously, I owe my deepest gratitude by each of the teachers, including my professor Jayadepati, who is sitting here. If I have prosecuted my law studies, he is responsible for that. And today I am standing here because of him, and I owe my deepest gratitude and pay my respect to him. Sir, because of you I am here. I seek your blessings. I must do much better. I must not let down in any manner whatsoever. I owe my deepest gratitude to you. I am deeply obliged that you are here to hear me, at least what your student has been telling and what you have taught, whether I have been taught properly or not. Then Honorable Justice M.C. Chagla was brightest and best judge in his time, who inspired him how to conduct himself in the courtroom. The eminent lawyer of his time, Mr. C.K. Daptari says, I quote, "It is better to spend more time think about a case than merely reading a brief." Again, I am repeating what C.K. Daptari has told to Alias Nariman, said that it is better to spend more time to think about a case than merely reading a brief. Suppose you have got 100 pages brief. You might have prepared the brief, you might have read the brief, but what will touch the minds of the court, it is very, very important. Very, very important. And if you think that this, I must make out my point 1, 2, 3, 4, this is my number one best point, it better strike to the mind of the court. If you not strike the mind of the court, then you are finished. Don't be harassed by that time. Suppose you place one point, you could not such, then come second point immediately. Forget why not, if I have no question first point, then I am shifting my point to second point, then third point. So these are the cases you have to do, but at least at one point of which is no point for you, may be best point for the judge. Again I am repeating, the thing which you think that it is a no point for you, it is a best point for the judge. If that is best point for the judge, you are to succeed, you are to deliver justice to your client. It is not that you have to browse the court, or you say that you do not know anything, don't ask anything, don't pose any question to us. That is not the way of good advocacy. The good advocacy is that you will question the court, you come to his class, and if you carry the court within pocket, then everything will get automatically. So that is the thing which you have to inculcate yourself and place before the court the best of the best point. Therefore, the very, very important thing which C.K. Daptari, the eminent senior advocate of this Supreme Court, has said, that it is better to spend more time think about a case than merely reading the brief. Then Alias Nariman was frequently asked by the law students across the country as to how a lawyer was to prepare for an agu important cases. I quote, his only appropriate answer, as best as you can. You just see how this 5 words find. As best as you can. That means, if your hard work, your labor, your perseverance, your eloquence, your readiness, your honesty, your integrity will club together, definitely best one will come out. And definitely best one will come out, and that will persuade the court to proceed in a manner which you want and drag the mind of the court to you and get the relief for your client, and that the justice seeker who is waiting at the corridor, he will think that is my law is trying hard to get this benefit. Therefore, my dear friends, my dear lawyer friends, I just tell you that these are all experiences which one has to inculcate, one has to share. Nowadays, many young lawyers have come up. I believe they are very, very intelligent, but have no patience. I don't personify any of the young counsels, but I see where they lack. And this is our observation as a judge. They don't have patience, number one. Number two, they never look at the seniors. Number three, they say that we have come up from a institution highly placed, therefore we are more intelligent, more educated. That is why what these judges are doing, they are LLB from the law college, they are LLB from University Law College, they are LLB from MS Law College, we have come from Jindal Law School, we have come from Symbiosis Law School, we have come from National Law School Bangalore, we have come from National Law School Orissa. Therefore, we are more intelligent than any other persons. But I find it's my observation that this class of ego, this nothing any personification. It's a only class of ego that I know much better than my senior. But dear friends, can you remember one thing? You might be very intelligent, no doubt about it. You may have an education in a higher institution, no difficulties. But your poor senior had the experience with him. He knows how to manage the court. He knows how to deliver justice to his client. He knows how to present the case before the court. He knows how to deliver the justice to his client, and that too, the manner of presentation, manner of understanding, manner of placing the things is very important. Therefore, my humble request to you that your intelligence one part, one's experience is other part, and one's age is one part, and your age is another part. Therefore, kindly do have the respect for senior. Kindly do have the share your experience with your senior. Kindly do have the understanding with your senior, because your senior has already seen many ups and downs in the life that you have never faced, because your parents are working as a protective umbrella for you. This protective umbrella will not remain all time to come, because when tomorrow your parents are not there, you feel alone and nobody with you. And I can assure you that if you have got semblance of respect towards your senior, then this senior will be the first person who will stand behind you in your difficulties. That is the greatest learning in this profession, which I understand myself, and this is the understanding of my brother friends, those are present here. Even if we feel helpless at times, some of our seniors say, no, don't worry, carry it. Even today also we have respect to senior members of bar, because they are the senior members of bar, they have got quite long experience with us. Even if we feel diffident somewhere, sir, can you help us? Can you assist us? So at least we can do something for this person. And I believe that when you extend your cooperation hand to the senior lawyer, I really owe gratitude to those senior lawyers. They are coming forward with smiling face and assist us to render the justice for the poor people. I salute those senior counsels, those are assisting us to rendering the proper judgments. Therefore, the essence of the good advocacy is to know the facts of your case, then apply law to those facts, then you argue a case in court, be clear and precise and not confused. Always think like a lawyer, not like a philosopher. When a judge wants to know something, you must tell him now, not later. I just pause here for one moment. I just point out, suppose a lawyer is arguing a case. A young lawyer, he doesn't have the practice of how to handle the court. Suppose the point is being advanced. The court wants to know, yes, Mr. Counsel, kindly answer this question. Then the immediate answer will come, I am coming. I have what not coming? We are posing one question to you. You are not answering, I am coming. As if you are asking the court to wait for you. Because the minds of the court is moving very fast. And if you don't answer it, you are finished. Because court will definitely take a view against you. See that I pose this question, but the lawyer will not answer it. Never say, I am coming. I am coming. I am coming to this point. and you say that, wait, I'm coming to that point. I'm coming to that point. Don't do that mistake. The earnest request to all the bar members that don't commit that mistake while having the advocacy for the court. Suppose the court wants a question, pose a question to you, kindly answer then and there without asking, I am coming to this point. I am coming to this point. Coming to this point means the court has to wait for you to get this answer. That should not be approach of a able counsel. I have seen my senior, when court poses a question, immediately will say, my lord, just this is my answer to your query, but your lordship may keep in mind, but I am just posing this question to myself and answering it in different way. You just see, he is not hurting the mind of the court. He answered it, immediately answered it, because he thought that court may be prejudiced against him if he not answered it. Therefore, once he answered it, then say, my lord, this is the answer, is all right. But my point is different one. This point I want to address for you, kindly take note of. Then he will draw the mind of the court what he tries to say. That is why he become big counsel, senior counsel, and that to admiral state. Then these are learning which are done during the course of our practice period. Therefore, instead of compacting with the court, rather you carry the court with you so that at least you all will get benefit out of that. And further, be updated with all reported judgments and decisions of the Supreme Court and High Courts. As always, it is your duty to bring to the attention of the court the case already decided on the point being argued, then distinguish your case from the decided cases and never cite an overruled case. It is improper. Once the judgment is overruled, if you cite the judgments and want to get relief and ultimately got laid down by the court, then you are finished. Because once the court loses faith in the counsel himself, then whenever he says also correct thing, you will take in suspicious eyes on you. The suspicion must go, don't cite and overrule judgments so that the court can take a prejudiced view against you. Rather, you be very fair, these are the points decided, this judgment is overruled. But this is my point. You can modulate your argument and proceed accordingly. There was a time when lawyer was regarded as a family friend. He commanded respect, and for good reasons, the prominent freedom fighters belonging to the legal fraternity and played a leading part in the framing of Constitution. Now coming to the present status of the lawyer. The present status of the lawyer is being regulated by the Central Act, the Advanced Act 1961, where Mr. Sifan Mohan is created. Bar Council of India, Bar Council of State, they are all the creation of the statute. Therefore, the chapter 1 of that advocacy deals with the preliminary, then chapter 2 deals with the Bar Council, then chapter 3 deals with the admission and enrollment of advocates, then chapter 4 deals with the rights of practice, chapter 5 deals with the conduct of advocates, chapter 6 deals with the miscellaneous, chapter 7 deals with the temporary and transitional provisions. Then by enacting such law, the authority has vested with the Bar Council to regulate the education, conduct, discipline of the bar members. Therefore, since the Act prescribes the detailed procedure, it is not required to explain everything now at this stage, because we are discussing things which is happening in day-to-day life as a bar member and bench. Now coming to the next question, what an advocate should do. I pose this question, what an advocate should do. 1. Organization, then 2. Learning. There are 3 ideas involved in the profession, that is 1 is organization, 2 is learning, and 3 is spirit of public service. These are essential. The urgent need for the legal profession is to become people oriented and to reorient themselves towards the service of the people. They must show recognition of what is meant by the service ethics or dealing with fellow human beings, needs without consideration of self-interest. Lawyer must serve as a healer, not makers of human conflict and sufferings. A lawyer, because of his importance in society and the respect that is accorded to the black gown, he had certain obligation to discharge both inside and outside of the court. A lawyer has a duty to his client and to the court. His duty to the court requires not only that he will prepare to assist the court, but also that he must be fair in pleading his case before the court because he is an officer of the court. He must not make statement of fact which is supposed to be false. In particular, in criminal matters, it will be misconduct on the part of the lawyer to implicate an innocent person deliberately in order to secure an acquittal of his client. Court expects the lawyers to cite cases which are irrelevant and relevant are important for the determination of the issue in question. Peace and justice are the essence of the necessity of every ideal society. It is duty of the noble advocate to safeguard law, assist justice, and help peace in the society, even at the cost of the monetary interest. The nobility of his profession calls for settling the disputes and avoiding furtherance of these disputes by every possible means. Thus, the advocate should put before his client the drawbacks in seeking court's assistance, namely expenses, prolonged process, hardship, etc., which will be avoided as far as possible. He should use the methods of persuasion and compromise for settling the disputes. The advocates enjoy high influence, prominence, and status in the society. He should utilize this to bring about unity, integrity, and peace in society. In this sense, we see that an advocate has a vital role to play in social circle. I am just pointing out here, after introduction of Section 89 to the CPC, there are different mode of settling the disputes. It may be arbitration conciliation, it may be mediation, it may be compromise between parties. Therefore, the lawyer having a reputation in the society has to make an endeavor first to see that how the dispute can resolve, the person must get the relief without going to the court first. If that trial he fails, then certainly he must point out what is good or bad involved in the case itself, how much expense he can get and how much expense he can incur, and the process which continues for closing of the case, time factor, everything has to be informed the client. Because otherwise the client will misunderstand you tomorrow, saying that, Jayadil sir, you have told me yesterday that my case will finish within short time, but it has already taken 7 years. Then Jayadil sir have only answer, it is civil suit. It will continue. One after file the petitions, petition has been rejected, then district court, then high court, then come back, then proceed. So these are processes. Even if you say so also, there is no excuse for that. Then client will underestimate you. The moment the client will underestimate you, then you will finish. If you make it clear from the very beginning, sir, it is a process, it will continue, you have to have the patience. Then he must say, as Jayadil sir told me that you have to have patience, then I am having patience, I have worked till I get justice. Then you will try to learn, encourage to see that how the relief can grant to you. These are the things we have to take care of when entertaining client with you at the time of filing the cases. The government enacts laws, the court administers them, whereas the advocate assists both of them for the fair functioning in their respective parts. The concept of welfare state has strengthened the role of the advocate in the implementation of various laws and policies, envisaging economic and social development, and also in the maintenance of law and order in the state. to be noble, the advocate must put before the court all aspects of case which are favorable to his client, but he must do so fairly, without misleading the court and without concealing from it anything that it is his duty to divulge. These pious duties and responsibility towards the court and the government have earned them a status of officer of the court. Therefore, lawyer become an officer. Lawyer become an officer of the court because of the fact that they have to discharge the pious obligation cast on them with regard to the discharging their function in the courtroom itself. Then, in view of such position, the advocate's profession derives the nobility necessarily from his moral, social, and national duties. It would be absurd to talk an advocate as a noble professional if he does not observe these necessary professional ethics and moral duties. However, in this context, it will be interesting to note that there is also a misconception among the people that the advocate's function consists of most part of the showing black as a white and white as a black. That means a lawyer said, people will say, but not the function of a lawyer. The black coat has given to you to have a protection on you. Black coat is not meant for to say something wrong or something good. Rather, the black coat is meant for giving protection to you because you will be known in the society as a lawyer. Your identity as a lawyer because of wearing that gown and black coat. That identity is lost if you open that and throw it out, then you say you're normal man. Therefore, the black coat has a tremendous impact in society. Then when you wear a black coat and gown with your body, then the protection which you get, that protection has to be given and create a immense respect for the society that he is a lawyer. So nobody dare to touch you. You are become untouchable because of that gown, that coat. So pay respect to that coat and gown. If you pay respect to that coat and gown, then you are saved. You are saved. You must be knowing that many lawyers from different political parties are here in one room. I am very happy that even if some diversification of political thought amongst the lawyers, when they sit in the court, in the bar association hall or in the court, they are all equal. They say we are advocates. That's a great identification for this category of people, even if they have got political activity differently, but in one place they hold themselves that I am a lawyer and I am an advocate, irrespective of the fact that I belong to any party faction. Therefore, the identity which I have got, that has been given a black coat only. They pay respect to black coat and gown, and that is sufficient because another aspect we cannot take into consideration. Because you wear this black coat and gown, you have got sustenance. You have got a family. Your family survived because of that. So don't misuse this coat and gown. The moment you misuse it, you have been thrown. The coat and gown will throw you like anything, and you will be nowhere. Have the respect towards your coat and gown and do the work for the dispensation of justice. The Roses in December, MC Chagla had quoted Johnson's witty. To defend the charge, the answer was, the advocate will not know it is to be good or bad till the judge determine it to be so. Indeed, the popular misconception for the profession as a whole is due to only few of the professionals who shamelessly put the required moral and professional values aside and unfortunately can compromise with themselves. Therefore, Johnson's line of thinking must not guide an advocate to act immorally. Then advocacy is definitely a noble profession, but the profession is necessarily an instrument in the hands of the men who practice it, and it is only ignoble men practicing this profession that cast their shadows to obstruct the light and light of nobility in this profession. These men in the profession are like sunspots or holes on the surface of the sun. but sun nevertheless shines and shall shine providing light and life. Same is the case with honest and duty-bound advocates. The advocates who observe their professional values and work with their soul with God within and God overhead, they really crown themselves with the glory of profession and can be proud of their profession in a true sense. To achieve the success in life, a lawyer, 4 principles should be followed, namely honesty, integrity, sincerity, and humility. All this point, at this point of time, a few thoughts of achieving success are placed for the benefit of all members of the bar. 1. Hard work, be physically fit, and value the time. The knowledge of English language, read literature, knowledge of computers, develop a hobby, look smart, aim high. Those who obey and follow the above conditions, I believe and trust that definitely will come out successful in this life. So these are the points which I have given to you. It is for your kind consideration, for your development only. Again, I am repeating the same point for your consumption, that honesty, integrity, sincerity and humility, these are the 4 basic principles one has to follow. In addition to that, one has to make hard work, then be physically fit. Suppose a boy is suffering from ailments, he cannot do cases because he is not mentally fit. One has to mentally fit first, one is physically fit. If one is physically fit, then he can deliver the goods. Therefore, one has to keep himself fit, physically fit. Then value the time. Value the time is very, very important. Court sits at 11 o'clock and district judge enters the courtroom at 11 o'clock. Your case will come at 11 o'clock. So remain present at least 10 minutes before the court sits. So make it out adjustment of time accordingly, so that when court enters the courtroom, you be prepared with the case and argue the matter before the court. And if court says the matter is called, you are not there, then court will proceed. He will not wait for you. So time is very, very important thing for you. And once you give importance to the time itself, then you will prosper like anything. Everything has to go on time. Time is very, very important thing, very, very essential. And you must plot your time accordingly. Suppose you are getting at 8 o'clock morning. Let us say, as young lawyers, they have got the habits of late riser. No problem for that. The habit of independent thinking and questioning should be inculcated. And above all, the junior must be exposed to and imbibe the noble tradition of the bar, the tradition of the truthfulness, the tradition of the fearlessness, the tradition of the fairness, and tradition of service to the indigent and disadvantaged. The members of the bar may have to play a dynamic role. It may perhaps become necessary for the leading members of the bar to come out of their ivory chamber and take a more active part in the public life. I have said all about the bar members. Now our turn has come. My question is the status of a judge. Honorable Chief Justice Y. Chandrachud, the former Chief Justice of India, has stated, I quote, the judges were not living in an ivory tower. They are also the persons coming from the same community of persons who have passed the law examination and who have joined as member of the bench or members of the bar and have all the qualities of ordinary individuals so far as success and failure are concerned. Whereas it can be said of the judges that they are not living in ivory towers. It can equally be said of the advocates that they are also not living in ivory towers, and their lives are also the very same houses of the miseries of an ordinary individual, and that the person also faces the same iron court. So far as the district judiciary is concerned, there are a number of factors chair to be seen and considered. Sometimes, when a very senior member of the bar appears for very junior members of the district judiciary, and he finds that even the basic approach of the question which is being put forth by him before the judge is not being considered, and at the same time the arguments may be at the advanced stage, the judicial officer may be busy in signing the court vouchers or attendance list or doing certain other miscellaneous job. It gives a sense of prejudice to the said senior member of the bar. Similarly, when the argument advanced by the lawyer had not been cared by the members of the judiciary, or when the lawyer feels that unnecessary remarks are being given, then by the court touching the personal integrity of the advocate appearing before the court or affecting the court in any personal manner, he feels hurt and loses respect for the court. It is the chair that receives the respect. Justice is severely second. The decorum of the court is destroyed and his dignity is spoiled. So therefore, I just point out the one thing to you that Master said the same thing. A young judicial officer having no practice experience, qualified in the entrance, in the competitive examination, joined in the as a magistrate, there is every possibility that he may commit some error. Therefore, you are the senior lawyers, you are the lawyers of practice of repute, can rectify the magistrate with all humbleness and pointed out the fact that please sir, look here, the mistake is committed by you to this extent. This is the provisions of law, kindly go through it. If necessary, the court may think, yes, I may be wrong, therefore I take some time. He may argue the matter, doesn't matter. Allow the court to apply his mind. Allow the court to function in a way he decides. Don't be hasty, don't be so serious about the things, so that at least there should not be any ill relations with the bar and bench. The good relations will continue only good understanding. That understanding you have to build between the bar and bench. Therefore, the question is that everything has to be done in a good understanding, in a good faith, for the purpose of knowing the benefit to your client, justice seeker, who is sitting outside the courthouse. Stating that yes, I have engaged Mr. Nirmala, he will definitely give me the benefit to me as a justice to me. And Nirmala, with his own ability and possibility, onto the matter, if he catches the needs of the person concerned, certainly he will be regarded as a good lawyer. And today, if you succeed one case, more you will get 10 cases. If you lose one case, you will lose 10 cases. Therefore, these are the things which you have to have, understand yourself and conduct yourself, so that at least the understanding should not go beyond the position. Then I am just pointing out that how the judges have been protected. The judge is well protected both in criminal and civil laws. The judge is amply protected in criminal law by provision of section 77 and 499, 7th and 9th exception of Indian Penal Code in respect of anything done while acting judicially or what spoken in the course of judicial proceeding. In civil law, the judge gets the protection of the Judicial Officers Protection Act 1850 in respect of an act done in the discharge of his judicial duty. In both the cases, only requirement is that good faith, which is presumed until the contrary is proved. Even if the protection is enjoyed by the court judge, but that doesn't mean it permits the judge to transgress the limit. Rather, he or she should be courteous, patient, cordial, amicable in his behavior, eager to learn and assist the junior members of the bar. Then only the relationship between the bar and bench will be very strong. The one on ideal relationship between the bench and bar, a rule has been framed by the American bar, which says, I quote, a self-respecting independence in the discharge of professional duty without denial of or diminution of courtesy and respect due to the judges station the only proper foundation of cordial personal and official relationship between the bench and the bar. There can be no doubt that the position and status of the judge entitles him to complete protection and immunity in the discharge of his duties fearlessly. Those who are appointed to administer the law should be permitted to administer it under the protection of the law independently and freely without fear and favor, and the ends of justice will be better secured if steady balance is maintained in the relations of the bench and the bar. Now comes to how the courtroom behavior should be. So far as the courtroom is concerned, it should be treated like a sacred place. The judges have to be respected and honored. Similarly, the lawyers should receive good treatment from the presiding officers. No lawyer expects a personal favor to be shown to him by the court. The lawyers are satisfied if their cases are heard. If who alone can put an endeavor to restore the lost glory of the profession by maintaining self-discipline and developing second line and next generation by training the juniors and actively involving in social service and charity. And the lawyers as a class are influential and resourceful, intellectually and economically. Their participation in social activities and politics will act as a deterrent to the undesirable elements and keep the stream of the society clean and ever flowing. One of the problems that the legal profession today is facing is overcrowding of advocates in it. When the number of professionals increases, all won't get enough remuneration. This will tempt them to adopt methods and habits which should derogate from the high standards of professional ethics, manners and behavioral pattern. This in the result will lower the prestige and usefulness of this time honored and noble profession. So it is absolutely necessary to check the flow of hands into the legal profession. Now some advocates have more than enough brief, which some others have no briefs at all. This also is not an ideal situation. Accumulation of too many briefs in some hands will itself cause delay in disposal of cases. On the other hand, those without enough file will restore the unscrupulous habits which militate against the professional values and standards and prestige. There is then the problem of delay in disposal and backlogging of the areas. Again, there is the question of unequal fight, irrespective of merit of case, between the parties with ample resources and indigent in dire need of but without adequate legal aid. The feeling is there that the cost of fighting a case, whatever might be the justice of the matter, is too exorbitant that most citizens can ill afford it to bear. This must necessarily take the average citizen skeptical and judicial process. In our legal system, is to prove effective and retain the faith and confidence of the average man, it must find an answer to the above mentioned problem. Now comes to technology besides the bar and bench. COVID-19 pandemic has opened another facet of dispensing justice. Computerization, digitization, e-filing, e-court, examination of witness through virtual mode, online courtrooms, paperless courts, e-library, and the various modes to adapt this speedy delivery of justice. Technology now playing a vital role for dispensing justice. Therefore, bar as well as bench has to cope themselves to match with the urgent situation. No doubt, the strength of the judges is much less in comparison number of cases filed in India. Increase in population, filing of cases and adjudication thereof are high in comparison to other countries of the world. There may be some error while passing the order by the judges. That itself should not prejudice any bar member. Rather, they should accept it sportively and test the veracity. Failure and success are the part of the human life. In view of such position, the bar members should adhere to the same with patience and do the needful for betterment of the client. I have got very few suggestions. If the bench and bar are to be treated as part and parcel of the scheme of and whisk of justice, the bar is particular places two formidable challenges. One, to keep the stream of justice pure and clean, and two, to improve the standard of the profession. Both go together and have to be taken up together for treatment. Unless the people get equal justice, and under the constitution, the justice is taken to the road of the poor, the legal profession will have to bear the cross, and that the justice is yet to be done. Then I conclude, if for an independent judiciary or independence of the bar, all should unitedly fight against it, irrespective of political affiliation. In these matters, there should not be division in the bar or political lines. A lawyer has to avoid moral obligation to uphold the rule of law and give effect to many of its principles in his daily work. In our secular state, a lawyer should strive to make reverence for the law and religion of the nation and make sure that nothing is done to lower the prestige and authority of the judiciary by anyone, however high or mighty. With the noble vision, not mere words but by deeds, and by practicing the profession of law in the spirit of public service, restoration of status, the dignity and the image of our profession, and play our rightful role in society and provide much needed service to the community and become a model for emulation to others. Really, I am thankful to you all for giving this great opportunity to me to share my views with you. And I expect that the deliberation which I made today have some bearing with each of the bar members and each of the honorable judges who are present here. And let us hope best for the tomorrow. I wish that young lawyers should rise up and they must take the baton from us to deliver justice to needy people. And I extend my thanks to Gora Chand Pattanaik Memorial Trust to give this opportunity to me. I really deeply obliged to the chairman and the trustee members that such a topic has been chosen and assigned to me, and what a onerous responsibility has given to me. I think I have discharged a little bit for your satisfaction, and I am hopeful that everybody will follow the same. Thank you for this opportunity.
Thank you so much, sir, for gracing us with your presence and enriching our evening with your expertise. Now, I would like to invite Shri Subhashish Pattanaik, Managing Trustee, to deliver the Presidential Address. Sir, please.
Namaste. Shubhashanti, good evening. I am Subhashish Pattanaik, Managing Trustee, Gora Chand Pattanaik Memorial Trust. Respected Honorable Justice Sarangi, Judge, Orissa High Court. Respected Honorable Justice B. Nursing, Respected Honorable Justice A.K. Mohapatra, Respected Justice S.S. Mishra, my respected elder brother, Advocate Sitan Divedi, Chairman Orissa State Bar Council, respected Chairman of the Trust Mr. Jagannath Das, respected members of the Judiciary, respected law faculties, professors, respected members of the bar, press, ladies and gentlemen. As a managing trustee, it is an honor to find you all in this august gathering. Your presence testifies the commitment to the values we offer, particularly the trust and interest in the topic, the bar and bench, the two facets of judiciary. Today, we are privileged to have two eminent persons of Orissa. One is Sitan Divedi, Chairman, Orissa State Bar Council, the leader of the bar, and Honorable Dr. Justice B.R. Sarangi, Judge, Orissa High Court, who has got most valuable experience in both bar and bench. When you asked for suggestions for the topic of the law lecture, Justice Sarangi spontaneously suggested for this topic. Since it is a very relevant topic in the present era, we immediately accepted such proposal and we are here today. Speaking for the bar, we could not find a better person than the chairman of the State Bar Council, Mr. Sitan Divedi. His insights and thought-provoking address on the issue such as role of lawyers in sync with the bench, capability of lawyers, and the eminent lawyers of the country. We find results under his visionary leadership and will scale numerous accomplishments. The trust is deeply obliged to Dr. Justice Sarangi for his words of wisdom on the issues such as meaning of the bar, qualities of the lawyer, reading habit, seniors chamber, help from senior lawyers, art of advocacy, use of technology in dispensing justice. These words will surely share the direction for a healthy bar and bench relationship for furthering the ends of justice. Before parting with, I am expressing my own views. Be it the famous Salem Bar Association case for uncapping the statutory upper limit of 90 days for acceptance of witness statement in the suit, or the recent judgment of Apex Court in the High Court Bar Association of Allahabad versus State of UP and others, wherein the automatic vacation of stay orders of the higher forums considered, and the famous Asian resurfacing case 2018-16 Supreme Court cases 299 was overruled. It is a sigh of relief for both bar and bench alike. It is always the bar association who came up to the rescue of the poor litigants. It is the bar which is the thought bureau of the society. Yes, there are some black sheep in this association, and it is always in every association. We have who are troublemakers for their own benefit, but the bar as a whole should not be blamed. Everybody knows what happened in Sambalpur last year. Less said, it is better. But the only silver lining in the incident is that it has put an end to the all kind of strikes and lockouts in the state. Thanks for my Lord Justice S.S. Vishnu who has argued the case in Supreme Court. Because of iron-fisted approach of the Apex Court, it is very difficult to fathom the degree of restraint and congeniality or any fixed principle for maintaining a healthy bar and bench relationship. It all depends upon the individual conscience of the members of the bar and bench alike. But a good and healthy bar bench relationship will give a big leap forward for dispensing justice. With these words, I take a bow and request Dr. Justice B.R. Sarangi to felicitate 3 members of the Bhubaneswar Bar Association on this occasion. Please come.
I am delighted to invite Advocate Shri Sangram Keshari Pradhan up on the dais.
फेसबुक लगा दे लगी जो
देखो
ठीक है ये ठीक है
Now I would like to call upon Advocate Srimati Joshna Mohanty up on the stage. Thank you, dignitaries. Now, I would like to request our trust members to felicitate the dignitaries on the dais with a token of gratitude. nearer to the end of this program, I would like to request Shri Subhash Kumar Satpathy, Trustee, to deliver the vote of thanks.
Good evening, ladies and gentlemen. On behalf of Trust, I would like to extend my heartfelt gratitude Honorable Dr. Justice Vidyut Ranjan Sarangi, Judge, High Court of Orissa, respected Advocate Sri Sutanshuman Dwivedi, Chairman, Orissa State Bar Council, respected Chairman of the Trust, Sri Jagannath Das, Advocate, Bhubaneswar, respected Managing Trustee, Sri Subhash Pattanaik, Advocate, Orissa Cuttack, Honorable Justice P. Narasinghe, Honorable Justice Aditya Mohapatra, Honorable Justice Shivasankar Mishra, respected member of the Judiciary, respected Bhubaneswar District Judge, respected law faculty professor, and all other judicial officers, respected member of the bar, press, ladies and gentlemen. It gives me immense pleasure to deliver the vote of thanks for this event to all the dignitaries assembled here. I would like to thank our chief guest of this evening, Honorable Dr. Justice B.R. Sarangi, who has delivered an informative, inspiring and important law lecture to the topic, the bar bench, the true facet of judiciary, is really added a value to the event and made it a great success. The chief guest, in spite of his busy schedule, has been given his kind consent instantly on the request of the trust to deliver the law lecture at Bhubaneswar. I am thankful to the chairman of Orissa State Bar Council, Advocate Sri Sutanshuman Dwivedi, who has given his kind consent to be the guest of the honor and inaugurate the law lecture by giving the keynote address. I am also thankful to the members of the judiciary who has given their valuable time for attending this function. I am thankful to all members of the print and electronic media who have assembled here to cover the program successfully. I am thankful to members of the bar, law faculty members. I am also thankful to our beloved Professor Jaydev Pati. I am also thankful to members of the bar, law faculty members, students and well-wishers of the trust who have given their valuable time to attend this law lecture and made it successful. Your involvement made a significant difference to today evening. Now I request all the present here to join us for the dinner. Thank you. Jai Jagannath. Good night. The Late Gora Chand Pattanaik Trust meeting is comes to end. Thank you. Thank you.
Thank you, sir. I would like to request all the trustees to please come up on the dais for a group photograph.
Yes, sir.